Dr. Greer, were you at all surprised at the sheer number of alleged damages?
Yes, that was extremely surprising. Sheer number alone was absolutely what was surprising. It does not matter what the time period was, because it was shocking to see. I've rented multiple places before. I've been an owner. I've never ever seen that amount of. She's not the first person I've rented from. I've never had that amount of damages ever, remotely, anything close to that. It's shocking to me.
The next case we have is Letitia Vasmir versus Mark Greer, and this is property damage claim. Who's here for the plaintiff?
Hi, my name is Malik Jiba. I'm the attorney for Ms. Vasmir.
Good afternoon, Your Honor. Jacob Smith for Mark Greer.
This is a civil case based on damages to property during a tenancy. Mr. Jiba, if you could call your witness and establish what y'all want to establish as briefly as possible.
Sure, Your Honor. So basically, this case is about Dr. Greer breaking a rental agreement and causing significant damage to Ms. Vasmir's home. Ms. Vasmir and Dr. Greer signed a rental agreement on May 3rd, 2021. Ms. Vasmir, is this the residential lease agreement that was signed between you and Mr. Greer?
Yes, it is. The lease was for 1 year and it was renewed 2 additional times, making the entire lease good for 3 years.
When was Mr. Greer supposed to vacate the property?
We had made arrangements that we would meet at the house on May 19th, 2024. And at that time, we'd do a walkthrough. Approximately 3 hours prior to our meeting, he sent me a text message that he was too busy and he would leave my keys with a neighbor I did not even know.
Ms. Vasmir, are you able to see?
Yes, I am. This is one that was before May 19th. He had contacted me asking about possibly extending the lease. Even though I had given a 60-day notice that would need to move out, he had later sent me a note with the possibility of extending the lease. I said no. I explained I had been away for a while and it was time for me to come back to Austin and I needed to move back into my home. He made it sound like that was a possibility, that he might be interested in purchasing the home. Then he also said possibly rent for 1 more year and then purchase the home.
Ms. Vasmir, what was supposed to happen at that day? Were you supposed to have a walkthrough and assess the damage to the home?
Yes, we were. Also asked if he would be getting back his security deposit at that time, and I reminded him that there was 30 days needed to be returned because that deposit was to be used to have the house professionally cleaned, carpets cleaned.
What sort of contact did you have at the time?
Phone number and an email address, and that was provided by the property manager.
And can you tell me what happened when you finally entered the home?
I was rather shocked by the condition the home was left in, knowing what condition it was in. He rented it. He did leave my keys. He did leave the pool pass, and he left 1 of the 2 garage door openers. He did not leave the mailbox key. When I reached out to him about the missing items, he said he didn't realize he had 2 garage door openers and he wanted to keep the mailbox keys because he had just put in a forwarding address. So he still wanted to have access to the mailbox to get any mail that might be sent to him.
Was this the document that you sent to Mr. Greer?
Yes, it is.
How long did it take you to assess the damage?
It took a little more than 30 days because I had trouble finding contractors that could come out and provide me with written documentation of estimates. As I said, as soon as I gathered as much information as possible, I did send this letter to Dr. Greer asking that he make good on the damages and waited to hear from him. Unfortunately, I had to mail it to what I was hoping was his place of employment. I wasn't even sure I was sending it to the right person, but I sent it registered mail to a medical office. I tried to hire local contractors. For example, I got one estimate from a big firm that was over $4,000. And then I got another estimate from a local contractor that was under $1,000. I wasn't trying to buy the most expensive thing or hire the most expensive contractor to do the work. Just someone that was competent, that would do the work, and if cost-saving measures could be taken, that's what I wanted to do.
And can you tell the court the extent of the damage to the home?
For starters, the carpet in the master bedroom, it had been new right before the tenant moved in. The carpet was stained so badly, professional carpet cleaners could not remove the stains. I have hardwood floors pretty much from the front to the back of the house. They were greatly scratched and they can be repaired. It's not an easy or inexpensive repair, but I've had this home 19 years, and in the 19 years there was one scratch in the hardwood floors. When I got back, they're a mess. mess. And it's almost a $4,000 job to get them repaired.
And are these the images of the hardwood floor at the time?
They are. Yes, they are.
Okay.
Your Honor, I object to any further testimony, especially Mr. Jiba showing the witness pictures of what she's describing here. I reassert my objection that this has not properly been offered into evidence, nor has it been admitted.
Sustained.
Could you tell us what these pictures are?
Objection, Your Honor.
Your Honor, my client took these pictures and she can authenticate them and get them admitted into evidence.
The pictures that are on the screen, these are all pictures I had taken when I had access to come back into the house, just to show the amount of damage. There was also my back door.
There's an improper foundation laid. This exhibit, Mr. Jiba has not offered this into evidence.
Rules of evidence don't apply in small claims court.
But they can if I say they can. If he's objecting to the foundation not being laid, I mean, that's a reasonable thing to say. We need to get the photographs admitted into evidence before she can testify about them.
Can you tell us what these photographs are then?
These are my backyard and the back patio. It appeared there was possibly a grill on the patio because there
Objection,
was,
speculation.
Right. Just answer his question right now.
again, these are pictures of the bedroom carpet, pictures of the backyard, pictures of the back patio. I took many of the pictures the first day I had the keys to the house, and then I came back the next day.
Your Honor, we would like to introduce the photographs and this itemization of deduction into evidence. Now, can you tell us about each line item here?
Just the fact that I was missing light bulbs in exterior light. When the house was rented, there were light bulbs in every socket. When I got the house back, not only was just about every room missing the light bulbs, but there were broken light fixtures. There's a small window beside the front door. It had a curtain on it for privacy. I don't know what happened. He broke the curtain rod. The ceiling light in the foyer, the whole fixture was missing. And that is something that I just went to Habitat for Humanity to replace. I have a pantry door. It's a bifold door. The door was no longer on its track. It appeared it may have been that way for a little bit of time because
The witness is speculating this.
the house was not in the same condition as when it was rented. There's no way I could have rented this house in the condition it was or with leaving that carpet in the master bedroom.
Did you have the house professionally cleaned as well?
Yes, and that's also in the lease agreement. In the backyard, I had weeds almost as high as the fence. All the ground cover had died. There was no grass left in either the front or the backyard. It's all weeds, all weeds.
And then tell the court about the state of the hardwood floor.
There are many scratches in the hardwood floor, and then there are some actual grooves. And there's one area that I thought it looked like possibly a wet towel had been left to lay on the hardwood.
Regulation.
As I'm saying, I had no idea what caused that damage. When I had someone come out to give me an estimate, their professional opinion was that someone had tried to fix something.
No, speculation.
Mark, I need you to mute yourself, please.
Right. You cannot say things like that. Leave it to your attorney to talk.
I'm sorry, Your Honor. I apologize.
Mark, you're still not muted. Your Honor,
Okay. Did you make a hearsay objection, Mr. Smith?
I did, Your Honor.
Okay, that's sustained.
I do not have $3,450 to have them repaired. There is also one other item I would like to mention, which was number 11, was my back door had been replaced. I have no idea why. I know it was replaced because I had a back door glass and it had window blinds on it. When I got back here into the home, there are no window blinds on that back door, and the back door was not hung properly.
In total, how much would it cost you to make your house livable?
The total repairs came to $7,044.93.
Is your house livable right now?
Yes.
Your Honor, we are trying to make sure what happens here is that a client's home is made livable again. I'll pass the witness for now.
Mr. Smith, do you want to ask some questions?
Yes, Your Honor. Thank you. Ms. Bessemer, did you ever create a move-in inspection report?
That was the responsibility of the property manager. When he initially rented the home, I had a property manager. They sent him a move-in condition report. I asked for a copy, and at that time, Key Renter Property told me he had never filled it out and submitted it to them.
At the time that you rented this property, it was Key Renter Property Management that was the property manager, correct?
Yes, and they took
Yeah.
pictures of the home.
That's not my question, ma'am. It was a yes or no.
Yes,
And at the time of the turnover of the property, Key Renter Property Management was not the property manager. Is that correct?
that is correct. Yes.
Do you know why Key key renter property management was not the property manager.
I received a letter from them 60 days before the end of the lease saying they were balancing their workload. And when they do that, sometimes they have to drop properties. And I was one that was being dropped.
So when that happened, you never thought maybe I need to go get an itemization, right?
No.
It is your testimony here that you do not have any before pictures.
No, I have plenty of before pictures. Key renters also did an inspection every 6 months where they came into the home.
Your Honor, may I have permission to share my screen?
Yes.
Do you recognize this document?
Yes.
And so this is the itemization report that was introduced into evidence. Is that right?
Yes. I wanted verification that he actually received it. It was mailed by certified mail. I did not know where to send it.
Did you do an audit of the damages?
Yes, if additional landscaping charges would be included. But yes, additional things were added.
I'm going to show you Texas Property Code Statute 92.107.
Why are you going to do that, counsel?
The witness has testified time and time and time again that because she did not have the tenant's forwarding address, that he is somehow not entitled to a return of security deposit.
She is not an attorney, so whether she looks at the statute or not is irrelevant. So let's move on.
I want to go back previously. Do you hang artwork in your house?
Yes, and it gets spackled and painted over.
Over 3 years, it is likely that different things may occur.
Things can happen. However, whenever there was a problem, he contacted the property manager.
And at some point, the property manager fired you. Is that correct?
Counsel,
From the
you don't-
Action, Your Honor. What's the relevance of this?
exactly. Response?
The landlord in this case is attempting to pawn off some responsibility to a rental agency that terminated their relationship.
We don't have any evidence that they did so in a negative manner, counsel. We have no evidence of that.
And I just want to confirm there is no move-in checklist and there is no move-out checklist, correct?
Correct.
I pass the witness.
Ms. Bassamir, do you recognize this document here?
Yes, I do. Every 6 months, they would come in, do an inspection, and they would just report back to me. Things looked okay. I had just informed Key Renter that I was not going to put the house up for rent again. I asked them to inform the tenant that the lease would not be renewed and he would be expected to move out at the end of the lease.
No further questions, Your Honor.
You rest your case?
Yes, I do.
We call defendant Mark Greer. Dr. Greer, generally speaking, what would you consider your treatment of the property?
I consider that I treated it actually with great respect. I had regular maintenance done on the house, the yard work. I had regular maintenance people come by that I paid on my own pocket, come once a week. I took care of inside issues. I didn't call Key Renter with every single issue, actually, as Ms. Bessemer had previously said. Quite frankly, there were a couple of things I just took care of on my own because I just thought it was easier. And they were actually a little bit of more big ticket items. Maybe I probably should have called Key Renter, but the back door she was asking about. Right after I moved in, there was somehow something blew into the window and broke the glass. So the door had to be repaired. I repaired it with my own accord. That would have cost her money, actually. I did it myself.
Did the landlord in this case ever ask you to provide a written condition form?
No, never.
So there was never a walkthrough conducted?
With Miss Bessemer, never. I was never made aware if there were any issues with the property. Every 6 months, I went through in detail. I'd walk around the house with the person that came by and ask about everything. I would ask them, is everything okay? Is this all right? Does this look okay? And
Do you recall what date you did receive itemization?
it was approximately 6 weeks after that. I believe it was June. I don't have in front of me, 29.
No further questions.
Mr. Greer, did you receive a form that would allow you to itemize the condition of the property when you took possession of it?
I honestly don't recall. It was 3 years ago. As far as my understanding with Key Renter, I talked to them and it filled out everything that they said was appropriate. I recall that I did everything they asked. I don't remember everything that was asked. I don't remember them asking me for anything extra forms. There was nothing they asked me further. It was rented. I've also been an owner. I don't remember doing anything.
What was the state of the property at the time that you moved in?
I don't recall any major damages. It looked like just a regular house.
Did you provide a forwarding address to Ms. Bassamir?
I thought she had my forwarding address. At that time, I did not have a forwarding address. I was in the process of moving into the new house. She had my email and my phone number. We'd contacted quite frequently, actually. I moved out, had stored my stuff with a friend temporarily, and then I actually moved into the new house about a week after I moved out.
But you did not provide her with this forwarding address.
She had all of my information. I thought that was appropriate. We've been communicating regularly. There's other texts that she's not talking about where she had my phone number and texted back and forth. There were some groceries that we were texting about. She had readily access to my phone, my text. She texted me. It was very easy to talk to me and get through to me. I wasn't aware that she needed my mailing address.
You testified earlier that Ms. Bassamir sent you the itemization about 40 days after you moved out.
I think it was a little bit later. I think it was about 6 weeks after I moved out.
Did that affect you negatively at all, the fact that you received this itemization at 6 weeks?
I think it should have been sooner. Not very much. It didn't affect me negatively.
No further questions, Your Honor.
Dr. Greer, were you at all surprised at the sheer number of alleged damages?
Yes, that was extremely surprising. Sheer number alone was absolutely what the the surprising. It does not matter what the time period was because it was shocking to see. I've rented multiple places before. I've been an owner. I've never ever seen that amount of, she's not the first person I've rented from. I've never had that amount of damages ever remotely, anything close to that. It's shocking to me.
No further questions.
Anything else from the defense?
Your Honor, just by way of brief summation, we would argue that it is a bad faith pursuant to Texas property code. The mere fact alone that Dr. Greer did not provide a forwarding address does not necessarily forfeit his right to an itemization. It is our position to this court that there is a presumption of bad faith in the retention of the security deposit. It is our position to this court. The landlord has not overcome that presumption.
Mr. Jiba, in a sentence or two, you want to wrap up?
Your Honor, the evidence clearly established the following. Dr. Greer was contractually obligated under the lease to return the property in the same condition as received, absent normal wear and tear.
I don't think that's the law at all, but go ahead.
That's based on the actual lease.
But it cannot contradict the law, though, correct?
That's exactly what the lease says as well.
You're only entitled to return less reasonable wear and tear. That may not be in the same condition you turned it over in.
That's what I meant. The property has to be returned in the same condition as received, absent wear and tear. The evidence that we provided clearly showed that there was significant damage that goes beyond normal wear and tear, whether we're looking at the legal definition or the contractual definition of wear and tear. As a result, Ms. Bassemere has incurred substantial costs. She was very clear in her letter. She wants him to compensate her for the damage that he caused to her home. So we are asking the court, as a result, to award Ms. Bassemere the full amount, essentially $14,723.97.
Wait a minute. I thought we were at 5244.
Your Honor, I am going to object to the calculation of damages. It is well settled that the plaintiff may only recover the amount pled for.
Y'all requested 5244.
Actually, Your Honor, that was the initial letter. We actually sent an updated statement of itemization.
I don't see an amended petition.
Be that as it may, the petition is very clear that the requested.
It's actually the document that the defendant provided earlier. That exhibit actually shows that the total damage would come out to $11,303.97.
Your Honor, respectfully, did provide that exhibit as yet another example of the landlord's bad faith in continuing to rack up charges. It is well settled law that the court may not award anything that is otherwise not pled for. Judgment must be capped at $5,244.93.
Yeah, absent an amended petition or something, I was assuming we were dealing with the 5244 as well.
I implore this court to wholly disregard anything beyond $5,244.93.
Okay, since we didn't get the evidence until today, there's no document for me to look at except what was on your screen. Normally, people present their evidence prior to trial. I don't have any documents to look at all. They're supposed to be submitted 3 days before the hearing, but
Yeah.
I don't see that any evidence was submitted.
I was planning to submit them this morning.
The hearing is today. It's why we like to have the evidence a little bit before the trial so we can look at this stuff. But in any event,
I apologize, Your Honor. That was the total amount we're asking for.
Objection, Your Honor.
everybody be quiet. I'm going to render the judgment based on the evidence presented and the amount based on the petition that was submitted without amendment. That's totally unfair. Based on the evidence, I find that plaintiff is entitled to $3,472.
Does that include attorney's fees, Your Honor?
Did you have an affidavit? So what were you going to ask for?
Yes, I do have an affidavit.
What are the hours and the rate?
Your Honor, I would proffer that this court should not entertain this affidavit as plaintiff in this has rested. Mr. Gavel
Now, he can give me his hours in time, counsel. You would have requested attorney's fees as well, correct?
Your Honor, respectfully, I would have requested them prior to resting my case as is procedurally proper.
I understand, counsel. I understand that part. I've already made my decision on what is due, and you guys are going to take this to county. Let me just put in the attorney's fees, and then we'll be done with the attorney's fees.
The hourly rate is at $300 an hour. Total number, I believe, was 11 hours, which comes to $3,420.
We will have the judgment out to you guys by email. It'll be dated for today.